The first one is who's the client and what industry are they in? We have a lot of volume on our desk as brokers and underwriters. The basic nuts and bolts of what a company does can sometimes actually get lost in the fray. And so you really need to understand the extent to which online advertising is a part of their business, or is it just a reputational issue for them? Obviously, if you're in the healthcare industry and you make certain statements, that's very different from if you're in the banking industry and you make different statements. Meet the CTO or the chief privacy officer or the CIO or the whoever can explain the use of technology in the organization. The other benefit behind that is what I like to call the classic infrastructure disconnect. It's when you get the finance guy who has never met the legal guy, or the legal guy who's never met the audit guy. So by getting those people in the room, you can actually, I think, learn a lot more about the exposure that you're underwriting. We can learn a lot more as brokers on how to advise our clients along these lines. These are just some questions you can ask in a meeting. Do you have a social media policy? You need to have an actual document that is circulated to all employees in the corporate organization, whether they sign it or it becomes part of the handbook, just like an IP agreement or any one of those other types of things. That's the kind of thing that I'm looking for in terms of advising a client on a best practice. Who is allowed to use social media? What types? And are they allowed to use the corporate brand? How do we protect our own trademarks and our own brand from ourselves, from employees or from outsiders that may comment back on threads that are issued via social media and dilute our marks or dilute our brands? Within that social media policy, are you monitoring the behavior of your organization? And are you monitoring it on a consistent basis, or at least a deliberate basis? Within that policy, to what extent are your employees allowed to make statements about others that are identifiable? In the sense that, I love LinkedIn. It has that fun little feature where if somebody looks at you, you can look back. And then there's people that think that they're smarter than that, so they're anonymous. But if you actually poke into anonymous, you can see it basically says like 66 DC, president of a brokerage shop. Oh, who could it be? You can figure it out. And if you can identify that person, then there's the potential for that exposure. So you need to make clear to your employees what they are and are not allowed to do. A lot of my E&O applications from you all in the room will say, send me your 5 standard or biggest contracts. And I always think to myself, what a stupid question. Because that contract may be in place since 1986. It doesn't have anything to do, in my mind, with the risks that are presented today. And that's industry irrespective, in the sense that it applies to anybody using technology. You don't need to be in the technology business to have the exposure. So have the contract provisions evolved? Do they have opt-out provisions? Do they have indemnification provisions that relate specifically to a data breach or the use of confidential information? All the IP-related indemnification provisions that we would normally look to as you're underwriting or you're consulting with a client. As you look at those provisions, the extent to which they relate specifically to the use of data, the use of images, the use of intellectual property, the better off you're going to be with regard to the contractual risk transfer that you're looking for there.